Silva. A typical job will find the company's dump trucks delivering sand and gravel or hauling debris away from a construction site, but a recent California Supreme Court ruling that redefines what an independent contractor is has muddied the waters and left this San Fernando Valley-based company and scores of other businesses in limbo. Marco Silva, who co-owns Silva, and that has created a problem. "We are seen as a threat," Silva said. "We're still working under our own terms because we're subcontracted to move materials. But anyone who hires us as an independent contractor could be sued because we are now misclassified. That leaves us without work." The ABC criteria Silva. Under the new rules, a person or business is considered to be an independent contractor only if a. They are free from the control and direction of an employer, b. The work they perform falls outside the employer's core business, c. They have their own independent business or trade beyond the job for which they were hired. The previous criteria included 11 determining factors. The most significant one was whether the person to whom service is provided has control or the right to control the worker, the work that's done and the way in which it is done. Nearly 2 million Californians. California is estimated to have early 2 million residents who choose to work as independent contractors, according to the U.S. Bureau of Labor Statistics, and that doesn't count people who supplement their income through online work. Attorney Theodore Boutros, who represents Uber, said in a filing with the Ninth U.S. Circuit Court of Appeals that month that Uber drivers should not be reclassified as employees. Register file photo. Scores of California industries, ranging from healthcare and education to filmmaking and transportation, have workers who have long been considered independent contractors, and the burgeoning gig economy is expanding the mix. On-demand drivers for Uber and Lyft also fall into that category. Does Uber qualify? Attorney Theodore Boutros, who represents Uber, said in a recent filing with the Ninth U.S. Circuit Court of Appeals that Uber drivers should not be classified as employees. Last year, a state appeals court in Florida said Uber's drivers were not company employees under Florida law. But state agencies in California and New York have said they are under state law. Enforcement of the new ABC rules in California has been spotty. But Laura Curtis, a policy advocate with the California Chamber of Commerce, said the State Employment Development Department is getting involved. "We hear the ED is doing audits," Curtis said. "We've seen cases filed against companies. Multiple employers whose workers have been classified as independent contractors are being sued because they should have been classified as employees." Silva, the California Chamber and other businesses have lobbied Sacramento to re-examine the ruling, but so far the legislature has taken no action. The new rules take away the flexibility independent contractors value so highly, and many say their income will take a hit. A 2017 Department of Labor survey found 79.1% of independent contractors preferred their current situation, while only 8.8% said they would rather have a traditional work arrangement. The change will also affect businesses. Employers that have classified their workers as independent will now have to cover medical benefits, workers' compensation, payroll taxes and other costs for more employees. A dietary consultant. Tina Kerrigan, a dietary consultant who provides contract service at skilled nursing facilities, assisted living homes and in hospice situations throughout Southern California, fears she'll soon see her wages drop. "With this new ruling we are at a very high risk of being reclassified as employees," the 55-year-old San Dimas resident said. "If that happens, I would lose all of my flexibility and I'd see about a 30% drop in pay. Most dietary consultants have at least a bachelor's degree," Kerrigan said, while many have master's degrees and additional certifications. "The pay for dietary consultants is usually much better than it would be for employees at an hourly rate," she said. "We do pay for our own benefits and we have to pay our own taxes, but we still earn more money. Plus, it provides work flexibility. I can make my own schedule. I can choose the hours I want to work, and I can work when and where I want." The Supreme Court case. The revised rules are linked to a California Supreme Court case that dates back to 2004, when Dynamex, a package and documents delivery company, converted its drivers to independent contractors in a move to save money. A few months later, a group of drivers sued, claiming they performed the same basic tasks in the same manner as when they were employees but without the protections of the California Labor Code and wage orders, which regulate wages, hours and working conditions. In April 2018, the court ruled in favor of the drivers. But it based its decision on the newly created standards that had never been used in the state. The court framed its decision by characterizing the misclassification of independent contractors as harmful and unfair to workers, honest competitors and the public as a whole. The ruling was based on a very specific and limited case, Curtis said. "I'm not saying that the court got the decision wrong. But the fact that it's now going to be imposed in a very strict standard on a much wider variety of businesses that didn't have the opportunity to hear the arguments and present facts, that's what concerns us." The chamber lobbied the state legislature to take up a bill that would pause implementation of the new rules for everyone except Dynamex, but that argument has yet to be heard. Under the new standard, it will be almost impossible for any independent contractor to continue to work that way, Curtis said. The I'm Independent Coalition, which seeks to protect the rights of people to work as independent contractors, said the Dynamex and the new ABC criteria should not be applied as a one-size-fits-all approach. The court decision leaves many unknowns on how it will be applied to every situation and industry, the organization said in a statement. There will be costly litigation to determine these unknowns unless the state legislature intervenes.